We'll hear argument first this morning in Case 13-6827, Holt versus Hobbs. Mr. Laycock.
Mr. Chief Justice, and may it please the Court. 40 other prison systems permit beards without a length limit, yet Arkansas prohibits even half an inch. And in their brief, they reject every means that courts have devised to evaluate their testimony. So what they really seek is absolute deference to anything they say just because they say it. And that would be to repeal this statute de facto. There may be deference to prison officials, but there must be concrete limits to that deference.
If this prisoner wanted to have a full beard, would RLUIPA require that the prison administration allow him to do that?
Well, some courts have said yes. There's very little in this record about full beards and whether they're safe or whether they're dangerous, but the 40 states that permit them suggest that the state would have a difficult burden of proof. But that question's not presented here.
Well, Mr. Laycock, the problem I have with your client's claim of religious requirement is the religious requirement is that he grow a full beard, isn't it? Now, let's assume I'm in a religion that requires polygamy. Could I say to the prison, well, okay, I won't have 3 wives, just let me have 2 wives. I mean, you're still violating your religion, it seems to me, if he allows his beard to be clipped to one inch, isn't he?
Well, the religious teaching is a full beard. He testified that religiously half an inch is better than nothing, and he explained that in terms of hadith that he referenced. He's in a very difficult situation. I don't think he should be penalized for being reasonable here. He offered an extremely conservative compromise to the prison.
Well, religious beliefs aren't reasonable. I mean, religious beliefs are categorical, It's God tells you. It's not a matter of being reasonable. God, be reasonable. He's supposed to have a full beard.
He's supposed to have a full beard, but a partial beard is better than none, and that's not just in secular terms. That's also in religious terms, which he explained on the record.
Okay. You think on the record that's what his religion would require if he can't have a full beard?
That's correct, Your Honor.
But, you're really just making your case too easy. One of the difficult issues in a case like this is where to draw the line. And you just say, well, we want to draw the line at half inch because that lets us win. And the next day, someone's going to be here with 1 inch, and maybe it'll be you, and then, 2 inches. It seems to me you can't avoid the legal difficulty just by saying all we want is half an inch.
Well, most of the cases seek a full beard or full hair, and sooner or later you will have to decide one of those cases. But this case, he made a pro se decision to limit his request. The court expressly limited the question presented, so this case is only about...
Well, but we have to decide this case pursuant to a generally applicable legal principle, and that legal principle is one, it seems to me, that demands some sort of a limit. And if you're unwilling to articulate a limit to the principle itself, it becomes a little bit difficult to apply it. Say, well, we don't know what the limit is, but because you're only asking a half inch, we'll apply a theoretical legal structure and say you fall within it.
Well, I think the limit has to be determined on a record in a case that is seeking a longer beard. I think what the larger issue than just half an inch that this case presents is how do you administer. The legislative history suggests deference to prison officials in the context of a compelling interest standard.
Yeah, so maybe this was improvidently granted. I don't want to do these cases half inch by half inch. Let's take a case that involves a full beard. The next case will be 1 inch, then 1.5 inches, 2 inches.
They're not going to come in that order. The next case is going to be most likely the next case is going to be a full beard because that's the great bulk of the cases. This case has a limited question presented and has a serious question of statutory interpretation. The courts below essentially applied the pre-RLUIPA constitutional standard. They gave essentially unlimited deference to the prison officials.
And what has this court said about the standard under RLUIPA with reference to prisons? That the prison has to show that it's least restrictive alternative in order to meet the requirements of strict scrutiny, and that's the prison's burden. Is that proposition established?
Well, your only prison RLUIPA case is Cutter, and that was a constitutional challenge. So this
do you think RLUIPA displaces Turner as the right standard?
It was clearly intended to replace Turner. It textually replaces Turner.
And what is the test insofar as you're concerned?
The test is compelling interest and least restrictive means, and deference must be administered in the context of that standard, not instead of that standard. So if it's a close case on compelling interest, they may well get deference. If they give a reasoned and well-considered and informed explanation, they deserve more deference. More deference would be due. Cutter says they get due deference, but Cutter had no occasion to decide how much deference is due or how that should be administered. The textual standard is clearly compelling interest and least restrictive means.
Could you put your answer in practical terms? The Chief Justice asked you, what's the legal principle that you want us to apply? And you announce it as give them the right deference. It's a little bit circular, the answer, in my mind. Looking at what the circuits have been doing, which one do you think articulates the best approach to RLUIPA and what courts should be doing?
Well, maybe Judge Gorsuch's opinion in the Tenth Circuit, but I'm not sure any circuit has given a fully elaborated account of deference in the context of a compelling interest test. We think the more reasoned and informed their explanation, the more deference is due. So do they give concrete examples of specific harms? Do they treat similar risks the same way? Do they take account of solutions that have been found to work in other jurisdictions? Do they take account of the religious needs of prisoners at any point, or do they just reflexively say no? If
the standard is other similar risks the same way, then what about a quarter-inch rule? Because that's what they allow to people who have dermatological problems.
They allow quarter-inch for medical beards. They don't allow even a quarter-inch for religious beards. But the quarter-inch, I think, for medical beards, I think, fatally undermines their claim that they can't administer a length limit, and it somewhat undermines all their other claims about a half-inch beard. This is in some ways like the case Justice Alito wrote in Newark on the Third Circuit. The medical exception undermines all the alleged reasons for not allowing a religious exception.
There are some religious practices. I think that the Sikh practice of not cutting hair ranks as a religious practice. So not cutting hair and wearing a turban, consistent with what you say is the standard. Could a prison say, we won't allow that because it is too easy to hide contraband?
Yeah, that may be. I don't know what the evidence would show about Sikh hair wrapped in a turban, but that's clearly a much more serious issue than what's presented in this case. Sikh hair wrapped in a turban may well be different, but we don't have any evidence about it in this case. We don't really have a way to know on the record in this case.
Mr. Laycock, you're relying on this case really on felt intuitions that this couldn't possibly advance the state's interest. But for the most part in these cases, there will be some incremental gain with respect to the interests that the state has. So whether it's a full beard or whether it's long hair or whether it's a turban, there'll be some ability to say, even though it's just teeny tiny, there's some increase in prison security that results from disallowing this practice. And I guess I want to know, and this really fits in with several of the other questions that have been asked you, is how do we think about that question in the context of this statute?
I think they have to show a material, this is a phrase in the government's brief, and I think it's helpful, a material effect on their security situation. Any teeny tiny risk, however small, is another way of de facto repealing the statute, because you can always imagine some teeny tiny risk. And even in Turner, under the rational basis standard, the court said the test isn't zero risk. Even in Turner, the court said you have to incur.
So teeny tiny isn't enough, but how about, measurable, although small? Or, at what point does it become something that we say, yes, we have to take that into account?